All persons having business before the court, draw near, give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning. We have one case on our docket today. It is 21-1221 American Coastal Insurance Company versus Marina Isle Club Condominium Association, Inc. Because this is a consolidated appeal with several issues, we are going to give each side 25 minutes. You, of course, do not have to use all of that time if you do not want to. I have set 5 minutes for rebuttal, so please let me know if you'd like additional time. Other than that, doesn't look like we have anybody in here, so if y'all could just both make sure that you have any sort of electronic devices silenced. Begin when you're ready.
May it please the court. My name is Ezekiel Lugo, and I represent the appellant in this case, American Coastal Insurance Company. I would like to reserve the 5 minutes for rebuttal. Judge Sasso, this court should reverse the final order in this case and remand for further proceedings so that the contractual dispute can be resolved through the appraisal process that was set in motion in this case. There are 4 reasons why the final judgment should be reversed. The first reason is that the final judgment does not contain findings of fact or conclusions of law. The second reason is that the petition asserted sufficient facts to state a cause of action for declaratory relief, and if it did not, American Coastal should have been afforded at least one opportunity to amend. The third reason is that the policyholder in this case agreed to the conditions under which the payment was made in this case by accepting and cashing the check. And the fourth reason is that the trial court or the clerk's office, it's not clear exactly who did it, when they sent the order, the final order to the parties, did not serve that order on all of the attorneys of record in this case.
If I could go back to the very beginning of the case in the trial court, can you please address the trial court's jurisdiction, either subject matter jurisdiction, procedural jurisdiction, given the petition that was filed in this case? Because under the rules of civil procedure, Rule 1.050 says every action of a civil nature shall be deemed commenced when the complaint or petition is filed. And then 1.100A says there must be a complaint or, when so designated by a statute or rule, a petition. And I'm not aware of a statute or rule that allows the type of petition that was filed, how it was titled in this case. So could you discuss the jurisdiction of the trial court?
Sure, Your Honor. The jurisdiction of the trial court is based on the fact that this petition was a petition filed, quote, pursuant to Chapter 86. And that's on the first paragraph of the petition on page 5 of the record.
But not all of the elements of a declaratory judgment action were really alleged in the petition. Would you agree with that?
I would agree that the magic words under which the court describes the 4 elements were not stated.
The party has doubt about their rights.
Correct, Your Honor. But the substance of the allegations in the petition were sufficient to put opposing counsel on notice that this was an action for declaratory relief. Those 4 elements are that there has to be a bona fide dispute. In this case, the petition alleged in pages 6 through 9 of the record, where the description of the dispute in this case is described, it alleged that the parties were involved in the adjustment of this hailstorm claim.
Where's there alleged, though, any sort of facts giving rise to a doubt about the rights?
Your Honor, the doubt is based on the disagreement, the nature of the disagreement about the effect of this conditional payment in this case. American Coastal, relying on the case law that's out there, the Fisher case that was cited in the cover letter to the check.
It's just a existence of an dispute necessarily convey doubt, though. I mean, the petition clearly seeks a certain relief. It doesn't allege any sort of doubt. It just says this dispute exists and this is what needs to happen because there's a dispute.
Right, Your Honor, but the doubt is inherent in the nature of the dispute and the facts that are alleged. If American Coastal needs to specifically state that it is in doubt as to its rights, then it should be granted leave.
How do we make that conclusion when we also turn to the prayer for relief, which also doesn't request any sort of declaration, and instead just request for an order compelling appraisal? Doesn't that counsel in favor of there being no doubt, and rather just a request for a certain relief?
No, Your Honor. The fact that that relief is being requested there is not inconsistent with an action under Chapter 86. And I can address several sections of Chapter 86 to explain why this petition fits within Chapter 86.
So going back to Judge Wozniak's question then, is it your argument then that just by referencing Chapter 86, let's say we disagree with you that the petition sufficiently alleges each action in declaratory judgment statute, do you think that the mere reference to Chapter 86 is sufficient to invoke the jurisdiction of the court?
Yes, Your Honor.
Okay, why?
At least to be allowed one opportunity to amend, to set out the statements, the allegations that include the specific reference to the elements as they are described in the case law. And this argument, Judge Wozniak, comes from the argument that was raised in the trial court by the policyholder attorney, and it was in reference to the case of State Farm versus Parrish from the Second District Court of Appeal, which is included in the record on page 469. And in that case, Judge Lucas, writing the opinion for the court, noted that that petition was deficient for several reasons. And the last thing that he noted is that it didn't even reference Chapter 86. This petition references Chapter 86, and it distinguishes it from the petition in the Parrish case. It should also be noted that the next part of the analysis in Judge Lucas's decision is that the appellate court had jurisdiction to review the order on appeal, because that order ended the litigation in the trial court, and parties in the state of Florida are entitled to appellate review of final orders rendered by circuit courts in the state. The Parrish issue was not raised in the answer brief. It's been abandoned on appeal.
Well, if it's a subject matter jurisdiction issue, I mean, we could raise that sua sponte. It can't be waived. Is that correct?
Well, this court has subject matter jurisdiction because there's a final order rendered by the circuit court.
But could we find that the trial court did not have subject matter jurisdiction sua sponte?
Perhaps, Your Honor.
Okay. And if you don't know, that's okay.
Yeah. I was not ready to address that issue because it was not raised in the answer brief, and there was no sort of order asking the parties to prepare to address the jurisdictional issues in the case. And if the court is really concerned about that aspect of the case, it should do what the court in Parrish did, which was to order supplemental briefing on the jurisdictional issue before it issued the opinion, and that's explained in Judge Lucas's opinion itself. Turning for the four grounds that American Coastal has raised in this case, the first one is that there's no findings of fact and conclusions of law.
Don't we need a valid declaratory judgment action before we get to that issue, though? I mean, would you agree there's no requirement to make findings of law and findings of fact and conclusions of law if there's not a proper declaratory judgment action before the court?
No, I don't agree with that, Your Honor, respectfully. So under Chapter 86, findings of fact and conclusions of law are required whether the final order is on the merits or it's a procedural dismissal based on failure to state a cause of action, and we cited those cases. Trump Endeavor as to the merits, Dynamic Cablevision as to the dismissal. But if the court agrees with the argument from opposing counsel that this was just a motion to compel appraisal, we have cited case law that in the analogous context of a motion to compel arbitration has found that a final order still needs to include findings of fact and conclusions of law.
And that was in the context of a personal injury action, right? So the jurisdiction of the court had been invoked through a complaint and a personal injury action, and that motion to compel came up later in the proceeding rather than the original pleading.
I believe that's correct. But that motion to compel arbitration was heard before the judge. There were arguments presented by both sides. That hearing ended abruptly.
But what's important here is not the analogous nature of a motion to compel arbitration and a motion for appraisal. It would be that the declaratory judgment statute directs courts to make those findings of fact and conclusions of law, right?
No, Your Honor. These are separate arguments. So under the declaratory judgment action, if this is a Chapter 86 action, then cases like Trump Endeavor and Dynamic Cablevision say that there have to be findings of fact and conclusions of law. If this is not a declaratory judgment action and it is just a motion to compel appraisal, which it is not, but assuming hypothetically that it is, then under the Sky Zone case, there should have been findings of fact and conclusions of law because the hearing ended abruptly. Page 640 of the record indicates that the judge ended the hearing without making any oral pronouncement of the reason for its ruling, took the matter under advisement, and when the final order came out, it simply says, denied. There's no findings of fact, there's no conclusions of law. And that's important regardless of whether it's a declaratory judgment action or a motion to compel appraisal because it makes the appellate review harder or impossible, especially in the context of this case where there was the jurisdictional argument that Judge Wozniak raised. There was also an argument that the petition failed to allege the elements for declaratory relief. And there was also the argument on the merits about the effect of the conditional payment. Those three arguments require different analysis, and there's no way for the court to know exactly what the trial judge did in this case. So because there were no findings of fact or conclusions of law for that reason alone, the court should reverse the final judgment. Now, if the court ruled the way it did, the circuit court ruled the way it did, because of the lack of, if it determined that the petition did not include the allegations for an action for declaratory relief, that was error. As I was explaining before, there was description of a bona fide dispute as to the parties' disagreement on the effect of the conditional payment. This type of action, that's the first element. Second element is there has to be a justiciable question. These types of dispute raise justiciable questions that come within Chapter 86. Section 86.021 is clear that the parties can use an action for declaratory relief to ask the court to declare their rights under a contract. Here, on page 6 of the record, the petition, second page of the petition, describes the contractual right at issue, and that is the right to an appraisal under an insurance contract.
So the lack of findings, I want to go back to that because it dovetails into the motion to vacate. Typically lack of findings is something that needs to be raised via motion for a hearing. I think the argument in the brief is that it was preserved because it was raised in the 1.540. So from what I understand from the motion, that it was the sole basis alleged in the motion was trial court error. Is that correct? In other words, there wasn't any allegation of excusable neglect or anything like that?
No, Your Honor. The petition alleged excusable neglect.
Okay. And do you recall where specifically in the motion that was alleged?
Yes, Your Honor. It's alleged on pages, it's part of the argument on pages 4 through 7, I believe, where there's a description of the case law dealing with orders that are not sent to the attorneys of record. Those cases, including the first one cited there on page 4, Gibson versus Boyce out of this court in 1980, explain that trial court has discretion to vacate a judgment under either 1.540A, which is a clerical mistake, and that's usually a clerical mistake on the part of the court, or under Rule 1.540 based on excusable neglect by the parties. And the cases cited thereafter, cases like the Leicester and Southeast Trucking, I believe is the name of the case. Those cases, Southeast Fidelity Insurance Company versus Truck Insurance Exchange, those cases have all been decided under Rule 1.540B, the subsection talking about excusable neglect. And the argument here is that there was excusable neglect. The motion for rehearing was not filed, not just because the attorney missed the deadline, but because there was a breakdown in the system. This was a system gone awry where the order, which was supposed to be sent to all attorneys who had appeared in this matter, was not sent to all attorneys that appeared in the matter. It was only sent to Ms. Sanders, whose name appeared above the signature line. It was not sent to the other attorneys listed on that signature block, which is on page 10 of the record, and that included Attorney Capps. His name was there. He designated a primary email address. He designated 2 secondary email address. It was also not sent to Attorney Segura, who likewise had designated a primary email address and 2 secondary email addresses.
Isn't your argument, though, predicated on the idea that the trial court was required to send the order to every attorney whose email address had been designated?
Yes, Your Honor, and that's pursuant to Rule 2.516H.
And so that is your argument for excusable neglect under subsection B, is that the trial court, there was excusable neglect because the trial court was required to send the order to every attorney of record and failed to do so.
Yes, and because the motion for rehearing was not timely filed within 15 days, because it was not discovered for that reason.
So help me with the requirement, how you're reading subsection H of 2.516, where the rule specifically says that the trial court must transmit rather than serve, so that the word transmitted instead of served is used to all parties, which trial court did here. And then when it talks to when the rule speaks to sending to the attorneys, it uses the language may.
Yes, Your Honor. The entire text of that subsection has to be taken into account. So the first sentence sets out the general requirement that there has to be transmittal. The remainder of that subsection explains, certain issues or requirements as related to that transmittal. The first one is, there doesn't have to be transmittal to parties who are in default. That doesn't apply here. The next sentence is the remainder of that rule explains the method, the 2 methods of transmittal which are permitted. One is by mail, and it talks about, the party submitting self-addressed stamped envelope. That does not apply here. The other method of transmittal is email. That uses a may because it's not the sole method. There's also that mailing procedure, the old snail mail, which doesn't apply here. So the 2 key sentences in that subsection are the first sentence requiring transmission and that last sentence requiring that if it's going to be done by email, it has to be sent to all attorneys of record. So that's the requirement under the rule that's at issue here. There is also case law requiring that orders be transmitted to all attorneys. There's case law holding that it's not enough that an order was sent to one attorney of record, but not another. That's the Southeastern case. And there's a case, the Leicester case, that says it's not enough that an order was sent to the party itself by mail if it was not sent to the attorney of record. So whether the court looks at the rule or the case law in this area.
How do we square those cases, though, with, for example, there's some of the cases out of the Fifth that talk about when the error in the trial court service is not due to the trial court but to the parties. I mean, there was clearly some sort of breakdown when the attorney moved to a different firm. So why, if the trial court looks at the rule and it says, I serve the parties, it's not my fault that I didn't know that she had transferred firms, is it an abuse of discretion for the trial court to conclude that it was not the trial court's fault and it was incumbent on the parties to ensure that the email addresses were updated appropriately?
Your Honor, the fact that there was no motion to withdraw Attorney Sanders, for example, does not affect the analysis in this case. The rule still requires that all orders be sent to all attorneys of record, regardless of whether an attorney has withdrawn or not. So even if she had filed that notice of withdrawal, there still had to be service on all attorneys. That's one part of the analysis here. The other thing that's relevant is that factually, the evidence before the judge, the only evidence was that Attorney Capps did not receive a copy of this order, and that a copy of that order was not sent to any email address at the @rumburger.com domain name, which was included in all of the emails that have been designated in that action. There was no contrary evidence from opposing counsel. There was not even a statement from opposing counsel that his office had received a copy of the order. There was no statement, there was no evidence from the clerk's office at all. There was no evidence in particular that if the clerk had received a notice of withdrawal, the order would have then been sent to the other attorneys who had already appeared and designated their emails in accordance with the rule. Those attorneys complied with the rule. They were entitled to service. And in this case, if Attorney Sanders made a mistake by not filing that motion to withdraw, it would be too harsh of a result to prejudice American Coastal, deny American Coastal the right to file a motion for rehearing because Attorney Sanders failed to comply with any requirement to file a motion to withdraw. The attorneys that did not receive the order in this case, Capps and Segura, they complied with the rule. They were still attorneys of record. Mr. Capps was the attorney who showed up at the hearing and argued the motion in front of the judge. Logically, you would expect that attorney would receive a copy of the order, and he did not.
And you're into your rebuttal if you'd like to reserve.
So I would like to reserve, Your Honor. I rely on the other arguments from the briefs and request that you reverse and remand. Thank you.
Thank you.
Good morning. May it please the Court, George Vaca here on behalf of the insured Marina Isles. As it pertains, I know the Court's very interested in all the procedural issues that have arisen in this case and been addressed by the parties in their briefs and at argument. I don't think I can do a better job articulating our position than I did when we wrote it in our brief. So if the Court has questions for me about that, I'll do my best to answer. But I think we've responded to all of American Coastal's procedural arguments. And then the question becomes whether or not this trial judge acted like no other reasonable trial judge would have under these circumstances where the judge knew that a previous order had been sent and received by them because he allowed my client to have a little bit more time to respond. That's in the record. That's not disputed. They don't talk about that. And they don't talk about why it is the judge's responsibility somehow to know how many different people in a large law firm are supposed to be receiving various things. The judge made quite clear he didn't know who was the partner, who was the associate.
Mr. Vaca,
Yes,
wouldn't
sir.
you expect that the attorney that argued the motion or argued whatever relief was being sought and was denied that request from the trial court would have received the order that disposed of the motion?
I'm not so certain about that. I've given this a great deal of thought because I know that in my experience with other circuit judges, not this one,
I don't know
wasn't.
what you mean by certain. I'm just asking, wouldn't you expect if you went and argued a motion in front of a trial court and it was you and another party in the courtroom in an adversarial proceeding with the trial judge and your request for relief was denied, wouldn't you expect that you appearing before the judge would have gotten or received an order?
In my practice, yes, but I don't have many names on our pleadings. I'm in a small firm, and where I was going with this is that the docket for some of these circuit judges is well over 1,000 cases. I have no idea what this circuit judge's docket was. I don't expect that he or any other circuit judge is going to remember every single lawyer who appears before them at a hearing or a Zoom hearing as these cases were going on at that time. I think that's unreasonable to expect that judge to remember all of that. So I think the judge...
standard under Rule 1.540B seems very broad. A mistake, inadvertence, surprise, excusable neglect. I think there's case law saying it is to be liberally construed in the interest of justice. So under the facts of this, how do these facts not meet, one of these prongs here?
I think what the judge did was he looked to the rule, expected that the lawyer who he sent the order to should have, if she was withdrawn from the firm, should have told the court that. I mean, his explanation is crystal clear in the transcript. It is, hey, we only have so many resources, the clerk and I only have so many things we can rely on, and if you're not going to help us out, I can't be expected to go search down all the lawyers who may have appeared before me. And in a way, I don't necessarily grossly disagree with what the appellant has said, but by the same token, I don't know if I can go to that point where I can say that this particular judge acted unreasonably. No other judge would have acted like him under the circumstances where the reason why somebody didn't get an order, according to how the judge saw it, through the docket and through his own eyes, was because that person didn't advise him that they were no longer with the firm, which is, to me, is a perfectly reasonable explanation to deny the motion.
Do you agree with the interpretation that the trial court is required to serve or to transmit the order to every attorney of record on the case?
I know what the rule says, and I can only say that in my experience, it's usually the lead attorney who gets the orders. So how the clerks do it, the rule says what the rule says. I'm not going to argue with the court about what the rule says.
So the lead attorney, so the affidavit that was filed does indicate that the lead attorney, Mr. Capps, filed the document. And under the rules of judicial administration in effect at the time he filed it, that would be the equivalent of a notice of appearance because he had filed the initial pleading. Service of parties is made typically to the attorney of record who has filed the notice of appearance. That would be Mr. Capps. So with that being said, why was it not error to ignore the lead attorney, the one who had filed the notice of appearance?
Actually, he wasn't listed as the lead attorney. That was something that came out at the hearing. That was what the judge was talking about. I don't know who's a partner and who's an associate.
And that wasn't precise language, but under the rules of judicial administration, for an appearance of an attorney, it designated that the attorney who filed an action would be the attorney of record. So I'm using lead colloquially for the term. So in other words, so why wouldn't it be error to not serve the attorney who had, under the rules of judicial administration, the only one who had really filed a notice of appearance?
Well, the only one who really filed the notice of appearance was the lawyer who signed the complaint, and that was who the judge sent the order to.
Signed is in the current version of the rules, but the rules in effect, it said the attorney who filed. And the only thing that we have in the record, as far as I can tell, of who filed was Mr. Capps. Ms. Sanders signed, but it doesn't indicate that she filed.
Well, I don't know who got the summons issued to them. I didn't check that before the oral argument, so forgive me, I should have done that.
Well, and we only have what's in the record, right? So,
well, I think that's in the record.
And if our record has undisputed evidence, and this was before the trial court as well, that Mr. Capps filed, and under the rules of judicial administration in effect at that time, that is the equivalent of filing a notice of appearance, or essentially accomplishes appearing in the case. Why shouldn't he have been served?
Well, there are 3 names on the complaint. So if the rule requires that all those names be served, the rule was not satisfied in this case. I can't argue otherwise. Mm-hmm. The question is, who was the one who was designated? And I know their argument is everybody was designated. The complaint itself was signed by the attorney who had left the firm. That person had received an order previously to this one under the same procedure that the judge used. There was never an objection raised, hey, you didn't send me a copy of this other order, or anything like that. Nobody brought that to the judge's attention. And so when this order came out, he followed the same process as he did previously, not knowing that anybody had a problem with it, not knowing that she had left the law firm, not knowing that now the partner was designating himself, because he went ahead and did that afterwards. He filed the designation with the motion for 1.540 motion to set aside the judgment. So somebody must have recognized that they didn't do something. Why would you file it again if you'd already done it? You wouldn't. And they recognized that themselves. That's why they did it. Because what they didn't recognize, this is a great argument that's been made, but the problem is, in real time, they didn't designate until after they filed, or contemporaneously with the 1.540 motion that they filed in the circuit court. And if the argument all along is, I already did it, then why would you do it again? You wouldn't. It would be unnecessary. So I think their actions, and how the judge viewed that under the totality of the circumstances leads me to say, I can't say that no other reasonable judge would have done what this judge did. And if we just have a strict reading of the rule, if every lawyer who's on a complaint has to be served, then the rule wasn't satisfied. And the court needs to do what the court needs to do with that, which I think then leads us to where the court got when it consolidated these appeals, which is, okay, you're going to have your procedural argument, it's going to be consolidated into this, let's get to the merits of this case. And that's really where I wanted to focus. We filed on Monday, I believe, with the court a notice of supplemental authority of the Williams case versus State Farm out of the 2nd DCA. And the reason why I filed that case, and the reason why we cite to Damasi, Landis, Zielinski, Fortune, Vest, is those cases absolutely define what the problem in this case is. And that problem, I'm sorry, yes, Your Honor.
Yeah, before you get to that, can we kind of jump back? There was the initial question on subject matter jurisdiction, which I'd be interested in hearing your response to. And then I also have a question as to the argument that if it was a motion or whatever and it was insufficient to invoke the subject matter jurisdiction, whether it would have been abuse of discretion to deny without leave to amend.
So the petition that was filed in this case, certainly not a model of clarity by any measure, in my humble opinion. But paragraph 1 says, it's a petition to compel completion of appraisal pursuant to Chapter 86 of the Florida statutes. There's nothing, the word appraisal doesn't appear in Chapter 86 of Florida statutes. So they're asking for relief pursuant to a statute, and then the ultimate relief that they ask for in the prayer is for the court to retain jurisdiction over the matter and enter an order compelling the respondent to complete appraisal. And then when they went to the hearing on that, the only thing they argued about was an order compelling appraisal. Now, the lawyer for my client went there and argued the parish case, said there was no controversy, Judge. There's nothing here to appraise. There's no case in controversy amongst us. They served a 624-155 subsection 3 payment. They cured the bad faith. That made everything go away. There's nothing for you to do here. That was the argument. And the judge agreed with that. Now, could the judge have said, I don't see a case in controversy or whatever? I guess he could have. But the facts here are undisputed in that regard. That's why we argued in our brief, hey, wait a minute. You don't need to have findings of fact and conclusions of law. The evidence in this case, the facts are just not disputed. We don't dispute that they sent the check. We don't dispute that the client cashed the check. We don't dispute we sent the civil remedies notice. We don't dispute the fact that they sent us a letter before they responded to the civil remedies notice.
Had the loss been fully appraised at that point?
It had not.
Okay. And isn't that also the intent of the time frame and the parties each getting their own appraiser and potentially having to resort to a third party to solve a valuation problem? That's the process we're talking about, correct? Wanting to get to the bottom as what is the evaluation of the loss?
Well, that's one of the things what the insurance company, so let me just...
No, but before you get to that, I mean, you've got to have an agreement or there has to be a determination as to the value of the loss, and then the insurance company pays.
No, sir.
To avoid bad faith.
Most respectfully, that's not accurate. If your honor goes and looks at the cases I just talked about,
The case that
Demasi?
you're citing, the case that you're citing, Williams does not deal with the placing of conditions on satisfaction of a civil remedies notice. Is that correct?
Williams does not. Williams deals with, the reason why I cited it is this argument that is being made to the court conflates contractual obligations and duties with the statutory duties. And Judge Sleet in Williams made quite clear, look, when we're talking about contractual duties, you're looking to the four corners of the policy. Those duties are wholly different than the ones under the statute. And then he cites the Supreme Court's decision in Vest. And Vest says, when you as the insurance company have the sworn proof of loss, which is what they asked for, which is what they received, then you have to do your job and adjust the loss. And we don't have to wait for an appraisal. There's no requirement that we wait for an appraisal to determine the amount. Whether you acted in good faith or bad faith is dependent upon what you did with the information you had that you requested. That's the issue. They wanted to avoid that lawsuit, and so they paid the proof of loss minus amounts they had previously paid. That's exactly what happened here. There's nothing in that statute that says, I can provisionally pay you anything and I've cured it. I can prevent a bad faith case.
This isn't an issue of whether or not the CRN has been cured. You're arguing that any payment, whether it's conditional or not, automatically ends litigation as to whether an appraisal is required, right?
Well, no. I think what my client did was say, hey, you owe us roughly $1.4 something million. They paid it. There's no controversy anymore.
Well, there is a controversy, right? So if we just take basic contractual principles, you say, pay me 1.4, it's an offer. You received a counteroffer. I'll pay you 1.4, but it's subject to XYZ conditions. So how is accepting that check not acceptance of the counteroffer?
Because the counteroffer was made as a cure payment under the statute. That's how they titled it.
And that's the jump that I'm not seeing linked through the case law. I mean, I think when you look at the statute, it just says that damages, it's cured, no action will lie if the damages are paid or the circumstances giving rise to the violation are corrected. Arguably here, the damages weren't paid. There was a payment tendered subject to conditions. Mm-hmm. Is that payment? I mean, that would be the dispute in a bad faith case, wouldn't it?
It probably would be.
So
except for they were taking the position that their payment precluded any bad faith case, effectively not allowing my client to cash the check.
How is, though, the ability to pursue a bad faith claim in this case dispositive of whether a party can compel an appraisal? Aren't they two completely different issues?
I think it's different issues. I think what the way this went down was, we have this amount in damages. Okay, according to Vest, what the insurer is supposed to do is figure out the amount of the covered loss, and if they want to cure, pay that. Okay, that's exactly what the Vest case says. And so what they tried to do, what they should have done, if they said if there was legitimately issues about, hey, there's elements of damage that aren't covered, they shouldn't have included that in the check. They should have paid what they were required to pay, what they acknowledged to pay. Because Vest says if you do that, not paying the extra amount is not necessarily bad faith. What's bad faith is not doing what's reasonable under the circumstances and handling it fairly towards your insured based upon the fact set that you have in front of you. So you have this entire world of information in front of you that's been provided. The sworn proof of loss, it's in the record.
I just feel like I'm wondering how we turn to the bad faith statute. So the issue that we have before, the trial court had before it, and then the merits, if we reach it here, is that under the insurance contract, there's an obligation to move forward with appraisal. So we're in contractual duties. To your point, contractual duties versus statutory duties. We are in contractual duties world still. And until that is determined, we can't, statutory issues is, I think what you've conceded, a separate issue.
No, I think that this is where I think they cross over, okay? So if you go to subsection C, It says, "No action shall lie if within 60 days after the insurer receives notice from the department in accordance with this subsection, the damages are paid or the circumstances giving rise to the violation are corrected." We took the position that the damages were paid. They paid us what we asked for. So there is no contract to interpret. They've paid. There's no bad faith case to go forward because they paid. There's just no controversy. That was the point that was being made to the trial judge. We sent them this civil remedies notice. They had 60 days to either pay the damages or fix whatever the problem was or not. They paid. We don't have a controversy anymore. That's what the argument is.
All right, I think I understand now.
So my thing is, if they cite to the, forgive me, I'm not good with names all the time, to the Fisher case. And the Fisher case, I think, deals more with the situation of, there's a controversy between some of the DCAs about whether or not you can go through appraisal even if there's a coverage issue, or you have to first go to the judge and get a determination of coverage and then go to appraisal. And so, and I think that's under Johnson versus Nationwide and what's the other case? Lycia. That the court considers issues of coverage, the appraisers determine causation for purposes of damages and appraising that loss. And so the Fisher case was one in which they went to appraisal, the coverage issues hadn't been fully determined. And that for reasons it's not articulated in an opinion other than they wanted to avoid bad faith, that they paid the full appraisal award subject to the clawback provisions that they tried to impose in this case. And for purposes of simply contractual appraisal, that's fine, because there's no requirement that's agreed upon by the courts about whether you have to go to appraisal first or you can go to appraisal second. There's no timing issue in terms of the coverage determination. So this was simply a coverage determination that was allowed in this particular case pursuant to that case law that the Supreme Court established 20 or 30 years ago. Here, on the bad faith side, you can do one of two things. You can either cure and pay or not. And that's what they did.
Isn't that still essentially in the context of this case a contractual issue? You're saying there's no longer a contractual dispute because it was paid. So
because they cured the violation. They paid the damages.
Right. So are you saying that if coverage is determined, an insurance company can never tender payment with conditions?
No, insurance companies should have tendered the payment that they thought was owed. And that's what Vest tells them to do. Not with conditions. There's no case.
So how is it a valid payment if the insurance company has tendered a payment with a clawback provision?
It was payment that
You're saying court should just sever out that clawback. You sent money. Doesn't matter if you attach conditions. It's the money
conditions
that matters.
aren't authorized by the statute. The conditions aren't authorized.
Unauthorized by the bad faith statute?
They're not authorized by the bad faith statute. They're not authorized by the Supreme Court's decision in Vest, which says you're supposed to figure out, take the sworn proof of loss, figure out what you owe, and offer to pay that.
And continuing with Judge Sasso's question, that means even if there's no complete appraisal or agreement as to the terms, you should just pay whatever you think is reasonable.
It's what the Supreme Court said to do in Vest.
In order to satisfy your statutory obligations.
Statutory obligations, correct.
Not necessarily what the contract requires for appraisal.
Right, but the statute requires different things. That's the reason why I started to go there, is as Judge Sleet wrote in Williams, there's two separate coexistent but independent obligations that run parallel with one another.
In order to pursue a bad faith claim, though. Not in order to pursue an appraisal.
No, you don't, forget bad faith for a second. Under the policy, they can invoke the appraisal clause and go appraise the case if that's what they want to do. What the bad faith statute says and what these cases say is, hey, wait a minute, just because you have that provision in your policy and you'd like, as the insurance company, to have a determination of the exact amount of damages before you have to pay it. What these cases say is, no, the bad faith statute doesn't allow you to do that. The bad faith statute doesn't acknowledge those conditions preceding to payment in that policy as affecting your civil remedies abilities to pursue the bad faith case under 624-155. That's precisely what the Williams court said. I think this court has said it twice in the context of what's required in a bad faith case in both Landers and DeMasi. The 4th District talked about it in Zielinski, and the 2nd District again in Fortune. All of these things separate, there's just 2 sets of duties. And what they wrote on their correspondence was they were trying to cure the violation. And they made an assessment. They made an amount, how much.
Going forward, does your client still have a bad faith claim?
No.
Your client doesn't have an avenue to still pursue bad faith even after this payment?
It was cured. The insurance company did what they were supposed to do. They cured it within the 60 days. There is no bad faith case. There's no breach of contract case. There is no case. There's nothing. They paid what was owed. My client has no additional remedies to pursue because they've received what they were supposed to receive. So the insurance company had a choice, right? The insurance company could have said, again, under vest, hey, we only think $1 million is covered, so we're tendering $1 million. Okay? Under that scenario, the appraisal would have went forward and completed. Depending upon how the appraisers ruled, they could have come back at the same or less, in which case there's no bad faith claim to pursue unless there's other damages. Or it could have come back more, could have come back at what our proof of loss was, at which case the bad faith claim would have been perfected. They hadn't cured. There was damages in excess of the amount owed. That's all already, and then they could have pursued that. But there was something that could have happened in between, which is the insurance company paid the amount that the insured said that they were entitled, precisely what they did in this case. And under subsection 3, no action shall lie if the damages are paid. So there is no bad faith action for my client at this point. Now, if the court were to reverse...
And your time is up.
Yes, thank you. Let me just finish. If the court were to reverse and the check in some fashion had to be returned, then there wouldn't have been a cure. The bad faith case would be perfected, and then we would simply put that off until another day. Thank you very much for your attention.
We have a little over 4 minutes remaining.
Thank you, Your Honor. May it please the court again. I would first like to clarify some of this confusion about the interplay between the contractual litigation and the bad faith action. And I would start by pointing out this notice of supplemental authority that was filed earlier this week. If you note, it says that it is relevant to the arguments, quote, regarding its statutory bad faith claim. Well, there's no statutory bad faith claim that has been pleaded in this case. That is not at issue in this case. This case involves the rights under the contract, the right to the appraisal, which is how the parties agreed they were going to resolve disputes as to the amount of loss. Appraisal provides the missing term of the amount of loss owed for a particular claim. That's what this case is about. This is still in the contractual litigation. The Williams case itself, Judge Sleet said, insurers have 2 independent duties, one contractual, one statutory. He also explains that the contractual part of the case of the duty includes determining the amounts due under the policy. While the contractual and statutory duties are related, they each have distinct procedures. The procedures that apply to the CRN and curing the CRN and whether there has been a cure under 624-1553 subsection C, that is not at issue in this case. The issue is the effect of the conditional payment, like Judge Sasso recognized, on the outstanding contractual issues, in particular the dispute as to the amount of the loss. We cited the case of Federated versus Bozinski that was decided by this court late last year, and that was a case where 3 months after filing suit, there was a CRN filed. The carrier timely cured the CRN by issuing payment, but despite the payment, the breach of contract suit proceeded to trial. That is factual evidence that the payment of a CRN does not automatically extinguish the underlying dispute between the parties. Because in a bad faith action, there is always an underlying dispute. It's usually a first party dispute as to property, PIP, but it could also be a third party dispute. There could be a litigation between a claimant and an insured that is the underlying litigation in the bad faith action. The payment of the CRN, whether that automatically extinguishes the contractual litigation, that's the question in this case. In the context of the conditional payment that explicitly said, we are making this payment out of an abundance of caution to avoid bad faith, and we are expressly reserving the right to seek reimbursement of any amounts that may not be owed under the policy. As to the jurisdictional arguments and section chapter 86, the court should remember 86.101, the legislature said that the chapter is declared to be substantive and remedial. And the last thing the legislature said is the chapter is to be liberally administered and construed. There's a separate section saying that the existence of a separate cause of action doesn't matter. Section 86.061 says that in a declaratory judgment action, supplemental relief may be granted. And subsection 86.0112 says that any person seeking a declaratory judgment may also demand additional, alternative, coercive, subsequent, or supplemental relief in the same action. So the fact that the petition for declaratory relief was asking for the appraisal process to be finished is not inconsistent with how the legislature crafted Chapter 86 and what the legislature allowed Chapter 86 to be used for. And there's multiple cases where courts have recognized declaratory actions filed to compel appraisal. There's the Phillips case, 3rd DCA, SafePoint versus Hallett, this court, 5th DCA. This court noted the Hallett's filed the declaratory judgment action seeking seeking completion of the appraisal process. That's what's at issue here. There was subject matter jurisdiction there. There's subject matter jurisdiction here. I see that my time is up, so I'll conclude there. The court should reverse and remand for further proceedings. Thank you.
Thank you both for your argument today. We'll be in recess.